Hey, what's up, everybody? My name is Onepeg. You'll have to apologize. The chest cold that I've got here. The air quality index outside is about 200. Yeah, it's not really helping my asthma at all. Anyway, we have an update regarding the Nexon versus Iron Mace case that I wanted to bring to your guys' attention. As of the video yesterday or the day before, whenever I uploaded it, we do have a new judge appointed to the case. Now, that doesn't necessarily mean that Magistrate Judge Peterson has recused themselves, but what it does mean is that the case appears to be moving at least one baby step forward, where a judge has now been assigned to the case as opposed to just the magistrate. It's relatively common to have the parties agree that the magistrate judge that was assigned to hear the initial complaint ends up being the person to preside over the remainder of the case, unless, of course, the parties don't like that the magistrate is involved, and then they end up having the federal court judge that's assigned to the case preside over the remainder of the case. And that appears to be what is going on here. Now, we have a couple of new documents, and this is something that I have from before with the judge assignment and people agreeing as to whether or not the magistrate is going to stick. But we have a notice regarding initial disclosures with a schedule, and then we also have a standing order regarding 28 U.S.C. subsection 455. So 28 U.S.C. has to do with the disqualification of justices. It says right here, any justice, judge, or magistrate shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. So in this case, what we have is whether or not that is actually in question, and we don't know. But just to cover the bases, Tana Lynn, who is the judge that was appointed to the case, has put out a thing saying that if anybody has any conflicts, you need to let the court know inside of the next week. So what they say specifically is a lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter or has been a material witness. So if any of the lawyers involved in litigating this case have a personal relationship with Tana Lynn, professionally speaking, that would be a conflict of interest, and the judge would have to recuse themselves and find a new one. In this case, what we have is a question in regard to whether or not the lawyer served at Keller Rohrbach LLP between August 2004 and November 2021. If no Keller Rohrbach lawyer has served as counsel in this case or any materially related matter, then you don't have to respond to the standing order. In the meantime, we do have language here talking about a schedule. So as of 3 days ago, we have a deadline for the FRCP 26F conference of 7/26/2023. Now, Rule 26 is FRCP is the Federal Rule of Civil Procedure. Rule 26 is about initial disclosures. Initial disclosures are required. Basically, it's a plan that the attorneys submit to say, this is what we're going to look at. These are the things that we're going to try to discover. Discovery meaning we're going to get all of our information together. And that discovery then will be placed on this outline for the court to review to say, these are the things that we plan on talking about, basically. Now, if we scroll down to 26F, this talks about a conference of the parties in advance to this bulleted list being brought to the court's attention. So we talk about except in a proceeding exempting from initial disclosure under Rule 26A1B, blah, blah, blah. The parties must confer as soon as practicable in any event at least 21 days before a scheduling conference is to be held or a scheduling order is due under Rule 16B. In conferring, they must consider the nature and basis of their claims and defenses and the possibilities for promptly settling or resolving the case. The idea here is that everybody's supposed to get together at the table with the judge present. They all talk it out, and there's a decision made as to whether or not this is actually something that can be kind of sort of agreed with. Can they agree with each other, or does this really actually need to see a trial? Because you have to remember, the docket, it only has so much space and time on it, and there's only so many judges. The idea being is that they're trying to, or the judge is trying to prod them into coming up with some type of resolution or settlement in order to not waste the court's time, money, and resources. This is, I guess, from what I've been told, it's kind of standard operating procedure. Now, from here, they have to develop what is known as a discovery plan. And regarding this, what this says is the disclosure talking about what that discovery plan is going to be is August 9th, 2023. And then on the 23rd, we have a joint status report and discovery plan as required by FRCP 26F. So we have the initial disclosure. These are the things that we're going to try and find and talk about. These are the evidentiary pieces and parts that are going to make up our stuff. And then we're going to have a detailed list of each one of those pieces of evidence and why we believe those to be important, and we're going to put that all in front of the judge. Now, the judge actually has procedural information written here, but there is an important blurb that talks about whether or not, if the parties would agree to it, to have a court magistrate oversee it. Remember, federal court judges, like the circuit court judges, are kind of one step below that of the Supreme Court. Now, there is the Court of Appeals, obviously, but then we have the Supreme Court. So a federal justice like Tana Lynn, her time is incredibly valuable to preside really over higher profile cases. And the determination as to whether or not this is going to be a high enough profile case to really involve a federal judge. Now, in this case, what they're saying is the parties have the right to consent to assignment to a full-time United Magistrate Judge and local magistrate judge to conduct the proceedings. The Western District of Washington assigns a wide range of cases to magistrate judges. The magistrate judges of this district thus have significant experience in all types of civil matters filed in our court. The parties should indicate whether they agree that the Honorable Michelle Peterson may conduct all proceedings in this case, including trial and the entry of judgment. There's also pieces in here about whether or not they want a jury, whether or not this is supposed to be a class action. It's kind of like a pro forma thing, meaning like everything is already pre-filled out. This is just a carbon copy that they give everybody, but they fill in the blanks with the pertinent, involved parties. Which is why this judge assignment was something that was sent out to say, hey, we need to know this from all of you guys if you object to this at all by the 28th of June. Now, we don't know whether or not Tana Lynn is going to stay on as the judge. If she does, I still say it's a good thing for the defense. But my knee-jerk reaction in all of this is that, and the thing that I still believe, and I don't, again, not a lawyer. I feel like I have to say this every time. Not a lawyer, but I feel like this is still going to end up getting thrown to the Korean court because the Korean court is trying the exact same case in the exact same way already going on in Korea. And there is a mountain of precedent cases that come before this where they have shown that the courts repeatedly, federal courts repeatedly, when there are cases that are ongoing simultaneously, tend to toss these cases to the local court because it's a lot easier for them to do it, especially considering that Korea and all of the development and all of the complaints and everything are centralized in Korea, and all of the evidence, 10,000 plus pages, are all in Korean, which brings me back to this schedule. So they're saying that they want report and discovery plans by the 23rd of August. So they were given quite a bit of time. We probably won't hear much of anything regarding this coming up in the near future. But there is also a thing in here regarding estimate the number of trial days required, name addresses and telephone numbers of all trial counsel, the dates on which trial counsel may have conflicts. So they have to schedule this out like way, way out there. There's also pieces in here about how long do you think you would be ready for trial? How long is this discovery process going to take you? And considering that, you have 10,000 pieces of evidence between both parties, 5,000 pages each, according to this Korean news article that we read out loud, 2-3 videos ago. According to that article, you have 10,000 pages of Korean language evidence on top of all of the server information, on top of all of the Git logs. All of that stuff would have to be translated from Korean and certified. Will take hundreds of thousands, if not $1 million+ worth of man hours and labor in order to be able to translate and certify all of those documents. And then those documents all have to be cataloged and submitted as evidence to the court. This is in addition to any witness testimony or the ability to be able to have people that would actually be able to testify and appear in court, remote or otherwise. And then you have to have translators involved. All of that will be an absolute circus and is probably what Nexon wants. Because in the case of this whole thing going on in the United States, we have a lot of money bleed. Nexon has an unlimited budget. They have a very large, very prestigious, very expensive, probably $1,000 an hour attorney law firm working for them day and night, and they love billable hours. So naturally, they're going to try to litigate this for as long and drawn out of a process as possible in order to milk Iron Mace for its legal defense funds. Assuming that Iron Mace runs out, that's it. When they run out of money, Nexon probably wins because the lawyers would end up having to back out of the case for not being paid. But obviously, in Korea, this is already ongoing. So we will still get a verdict one way or the other. In the meantime, it looks like this is going to be pretty radio silent until such point as we end up being seen whether or not we're going to have Michelle Peterson reassigned as the presiding judge over this case, and whether or not we're going to end up seeing that dismissal granted. Those are probably the biggest two pieces of information that will be coming up in the near future. From here, it's going to be a matter of watching the Korean court case and seeing how all of that goes. But in regards to Iron Mace, unless there's an announcement of a new playtest in the next 3 weeks or so, we probably won't have much information about this case for 2 to, I'd say, 3 weeks. Until then, chat. Until then, I thank you guys for coming and checking this out. I apologize for my voice sounding so tired. Thank you all so very, very much for coming and watching my videos. It really does mean the world to me. I really, really, really appreciate that you guys have been here for the last 5+ years, just kind of chilling and watching. This has been life-changing for me, and I cannot thank you enough. So thank you guys so very much for being here and for supporting me and being subscribers to the channel. If you're subscribers, if you're not subscribed, please consider subscribing to the channel. It really, really does matter. As always, I am live at twitch.tv/Onepeg playing video games of a wide variety of types, primarily Escape from Tarkov for all the OG fans. But I will absolutely see you in the next video, whatever that video may be. All right, we'll see you soon. Peace.